I see. All right, welcome back. Hi. So I recognize probably 90% of you, which is very good. Those who I don't know, my name is Josh. We'll be doing First Amendment this semester. Unfortunately, the cable to connect the computer is bolted under the desk, so it's not going to reach, so I won't be able to use it tonight. I apologize in advance. Okay, a few preliminary things. The attendance uses the iReef app. I can't project on the screen, but I think most of you have already checked in. So please download that when you can. Second, you probably already know, if you don't have one already, I have these little tent cards. If you can just pass these around and put your name on them, that'd be very grateful. Just nice, big letters. Whatever name you want me to call you, I will call you that. I don't care what it says. Doesn't matter. Nickname doesn't really matter. Just put your name in nice big letters. Second, I think so. It's a little tradition of mine that every year I give cookies in the first day of class. So I have these from Costco. They're very good. So please start right over here.
Thank you.
Pass these around. Make sure everyone gets one. Okay. Here you go, sir. Third, I always give out in con law a pocket constitution. In this class, we'll be focusing on just one amendment the entire semester. But please pass these around. If you have one, take another one. It's fine. I have a lot of free ones. Start over here. Make sure the guys in the back get it also. Okay. I think I got that. Okay, good. What else administrative? All the classes are recorded on YouTube like before. If you took me in the past, I didn't have this little fancy camera. It's a much better camera. Now I have a microphone right on my tie, so it sounds a lot better. So the audio will be a lot better than what you might have had in the past. I've upgraded a bit. All right. What else? Okay. The case book, if you already had me for con law and used the Black and Barnett book, you're good. If unfortunately it took me about 3 years ago and you have the older one, you have to get a new one, but you should all have the same book. If you need the page numbers for a different edition, you can just email me and I'll figure it out for you. The readings in this class, I think, are actually lighter than in con law. As busy as con law was for 4 hours, con law and First Amendment is a little bit slow. I think we actually have more time to think about it, which is good. Also, unlike 1L, you all want to be here, right? You actually chose to take this class. You weren't forced to take it. And I think that reflects a different type of student, which requires a little bit more interest in the subject matter than you may have as a 1L. All right, what else? Anything different? No midterm in this class. No midterm. No midterm. Not for an upper level. If you want to take one of my old con law exams for practice, you can, but there will not be a midterm. Final exam with the same format as last time with the 2 questions and 1,000 words apiece. Again, I apologize. They bolted the cable for the projector to the floor, and it's not going to reach here. So we have no projection today, but I didn't really have anything to show otherwise. OK. Got the cookies, got the constitutions, got the name tags. Went over the format for the exam. I think I got everything. Any questions from any of you before we get started? What was that?
Officer of First Amendment is my name. That's fine.
I'll call you whatever you want. It doesn't really matter to me. OK. Thank you. All right, so let's start. You all have your pocket constitutions. Page 65 is probably the only page you'll need the entire semester. We have a lot to cover with just about 5 or 6 lines of text. So let me give an overview of the class, right? First Amendment says, Congress shall make no law. First, respecting the establishment of religion. Okay. Second, prohibiting the free exercise thereof. Third, abridging the freedom of speech or of the press. 4, abridging the right of the people peacefully to assemble. 5, abridging the right of the people to petition the government for redress of grievances. We start with the free speech and press clause. That's chapter 16 of your book. Second, we move on to freedom of association. That's chapter 17. Next, we move on for the free exercise of religion, which is chapter 18. And then we do the establishment clause, chapter 19. And for a bonus fun day in the last day of class, we do the Second Amendment because it gets no love in any other class in law school. It's the only place it's going to fit it. Thank you so much. Anyone else need, please just come up and grab it. Got lots of constitutions. Okay. So our study begins with a question, right? Oh boy, McKinney, I'm sorry, you're there. So the question's this, right? What gives Congress the power to censor the press? What gives Congress the power to regulate the press? That's where we start off.
It's a tough one to open up with because the Constitution says they're not supposed to do that.
Oh, okay. So in 1791, the First Amendment was ratified, right? It says right there, Congress shall make no law abridging freedom of the press. What if this law was enacted in 1790, before the ratification of the First Amendment? So I'll ask the exact same question. What law gives Congress the power to censor the press in 1790?
A specific law?
What power does Congress have to censor the press in 1790? That's your question.
They're the sovereign. The government basically has the powers they let themselves have.
Okay. So Nathan, what's the source of Congress's powers?
So, consent of the people to allow them to govern us.
And where do we know what the powers of Congress are? Where do we find that?
We find that in the Constitution.
Where?
The first Article 1.
Section? I knew it's right. I lied when I said we only do one page. We'll do other stuff too, I'm sure. Article 1, Section 8. Okay, right. So we start from the basic premise, and this is the lead-in to our topic on the Sedition Acts. Congress only has those powers that are enumerated. They can regulate commerce. They can lay and collect taxes. They can establish postal roads. There are a few things they can do, about 20 or 18 or 19 clauses. I always forget the count. But there are specific things Congress can do. We also have the Necessary and Proper Clause, which provides an independent grant of power to make laws that are necessary and proper to execute the other powers that are enumerated. So all that's good, right? Is there anything in Article 1, Section 8 about restricting the press? The answer is no. You can scroll through it. I won't waste your time, right? So this is why I framed the question this way. In 1790, before the First Amendment was ratified, would Congress have the power to even censor the press, to pass a law to punish people for criticizing the government, for example? And I think the answer has to be no under a fair reading of the Constitution. But we don't all agree on how the enumerated powers doctrine should be understood. I'll bring you back to a case I know you studied, with maybe me or elsewhere, which was McCulloch against Maryland, right? Very early case decided by the Supreme Court in the 1820s. And the question was, did Congress have the power to establish a national bank of the United States, right? A federal chartered bank. And you had this debate in the Washington administration. Imagine this. You're George Washington, you're president, right? And you got Alexander Hamilton and Thomas Jefferson sitting right there. And you ask them for opinions. And you recall that Thomas Jefferson and James Madison thought, nope, you can't charter a bank. There's no enumerated power that allows you to charter a bank, right? It's not regulating commerce. It's not collecting taxes. Then you had Hamilton, who had a much bigger understanding of federal power. And then Hamilton says, yeah, you can charter a bank. Necessary and proper, right? As a necessary and proper means to regulate commerce and lay and collect taxes, it's useful, maybe convenient, for Congress to have a federal bank. And who did Washington go with? He went with Hamilton. And that led to the creation of the federal bank. So even though we can all sit here and say that Congress has no power to censor the press, no enumerated power, what if Hamilton's right? Maybe Congress can say we need to censor the press to promote national security, right? As a necessary and proper means to wage war against foreign countries, we have to restrict the press. Is that an insane argument? If we take McCulloch and John Marshall and Alexander Hamilton at their face value, is it insane to say that you need a free press, even in times of war, that Congress can facilitate a more effective war effort by restricting the press? I think it's nuts, but it's within, I think, the range of what Hamilton and definitely what John Marshall wrote in McCulloch. So one of the backdrops of the First Amendment was a recognition that even if Congress doesn't have the affirmative power to censor censor newspapers and printing presses, that the necessary and proper clause, this elastic provision, could provide the requisite authority to enact a law like the Sedition Act. So as you go through this semester, I want you to keep in mind two protections, two bases of protections for free speech, right? You first have, does the government have the power to do this? Does Congress have the power, enumerated power to enact this law? Later, do the states have this power, right? Is there delegation for the state or Congress to enact this law? So that's like the structural limitations protect free speech. Then we also have the stuff you probably care about, which is the Bill of Rights, the First Amendment. And it says, Congress shall make no law Congress shall make no law prohibiting the freedom of speech. Look at that, the way it's phrased. Congress shall make no law. It doesn't say you have the right to free speech. Lots of state constitutions say that. It doesn't say we all have this freedom because the government gives it to you. It says Congress shall make no law. This provision reinforces the structural argument. It's saying Congress cannot pass a law that abridges the freedom of the speech or of the press. Okay? So even the Bill of Rights operates in a structural way. It limits federal power to enact certain types of laws. But there's still a positive version, like a rights version. What can Congress not do? They can't enact laws that restrict the freedom of the speech or of the press. But what is abridge mean? What does freedom of speech mean? What is freedom of the press? We know Congress can't pass a law abridging it. But what do those words mean? We will spend, I'm not joking, like 7 weeks on what abridge, freedom of speech, and freedom of press mean. And I don't think I'll give you a good answer. You're not going to be happy with whatever answer I give you because it's based on the Supreme Court. So you have to look at this both in terms of structure, right? Congress can't make a law, great. But also, what does it mean to have freedom of speech? Right? What is the basis of the freedom of speech? And the chapter, I think, lays out some history, if you will. We'll get to the Sedition Act in a couple minutes. But when we look at the text of the Constitution, we always have to consider where it came from. And the idea of the freedom of speech and freedom of the press was a very important aspect of the Anglo-American tradition. If you look at the English Bill of Rights, which were rights secured against the King of England, one of the essential guarantees was the freedom of the speech and the press. Why? So that people will be free to criticize or maybe praise the government without fear of retribution. If the colonists in the 13 colonies didn't have the freedom of the press, we would probably still be a colony of England, right? One of the core attributes of the independence movement were pamphlets, basically tweets for the day, right? These short missives that were used to criticize King George and Parliament and the various restrictions on the liberties of the colonists. But what does it mean to have freedom of speech? There are two major conceptions of what this phrase might mean, right? The English version, what's often attributed to Blackstone, the great English jurist, is what's known as a prior restraint of speech. What does that mean? The government can't stop you from speaking, right? If you want to say something, they can't stop you in advance from saying it. But, and here comes the big but, they can punish you after the fact for saying it. So you can go and badmouth the king all you want. Glad you got it off your chest. You're going to be thrown into jail now. All right. This is the Blackstone model of the freedom of speech. No prior restraints of speech. But then we have more of the American model, and James Madison discusses this in his report. We'll get to all this in a minute. I'm giving you a frame. And Madison says a little differently. He says, yeah, you can't have prior restraints, and you also can't punish someone after the fact for engaging in speech, right? It's a before and after, or if you will, ex post and ex ante, right? Both before and after. You can't punish someone for engaging in speech. Now, you might say, wait a minute, Josh, I took torts, right? And we learned about libel. We learned about slander. If I say a false statement about someone and I injure the reputation, they can take me to court and they can sue me. And a judge can issue a judgment against me for slandering or defaming a person. What do you mean you can't be punished after the fact? I thought this is America, right? Welcome to the First Amendment. Is slander and defamation within the freedom of speech? And historically, the answer is no. So in this course, one of your challenges is going to be placing different categories of speech, either inside or outside the freedom of speech, right? If it's a type of speech that's protected, you can't be punished for saying it. If it's maybe a different type of speech, maybe you can be punished. Ditto for prior restraints. With certain type of speech, the government can't stop you from speaking. What if you want to publish, say, classified information about how to build a nuclear submarine? Yeah, they can probably get an injunction to stop you from disclosing classified information. Maybe, maybe not.
What about like censorship of like music?
Obscenity. We'll do obscenity, right? Now, there's a difference between pornography and obscenity, but courts have held that if you want to exhibit an obscene film, obscene is something different than pornography, but if you want to exhibit an obscene film, they might get an injunction to stop you from exhibiting it, right? I'll give you a live issue. As many of you know, I'm always on an airplane. After class tonight, I'm hopping on a plane to Austin. Tomorrow, I have an oral argument on a First Amendment case. You may have seen that I'm representing Defense Distributed, which is the group in Austin that wants to publish the plans to make 3D printed guns. And we've actually sued a lot of people. But we sued most recently the state of New Jersey to try to challenge one of their laws that makes it a crime to put a file on the internet. Indeed, it's a crime to share a file on the internet of how to make a gun. So I'll be arguing tomorrow morning at 10 a.m. in Austin. So this class is actually my warm-up for that. Seriously, I was reading like Holmes, yeah, to Abrams, good for class. All right. Okay, so any questions in the general frame? Okay. So let's start with the Alien Sedition Acts. I think what you'll all learn is that there's nothing new under the sun. Whatever political battles and fears existed in the 1790s exist today. Just substitute Russia for France. Imagine this. There's fears that a high-ranking government official is an agent of a foreign country and is trying to subvert the United States. So they enact these laws to perhaps figure out what's actually going on and punish it. There's nothing new. So the Sedition Acts and the Alien Acts were passed towards the end of the Federalist Party. You'll recall from our study of Marbury against Madison that President John Adams was in office for only 4 years. He lost the election of 1800. And on his way out the door, he enacted the Midnight Judges Act. They put all these judges in at the last minute, and we had Marbury. But before we got to the election of 1800, we had the Sedition and Alien Acts. These were laws enacted by the Federalist Party Congress out of a fear of foreign influence. I'll mention the Alien Acts briefly. They're not really relevant to your class, but they were very important. The Alien Acts gave the president the power to deport people unilaterally by himself if he deemed them detrimental to American interests, dangerous to the peace and safety of the United States. There was no courts involved. It was a summary deportation. Now, the law applied to two different kinds of people. Those from countries we're at war with, so say we're at war with France, no problem, right? There's no problem to deport someone from a country we're at war with. That was understood. But also applied to friendly nations, those we were having peaceful relations with. And that was a huge deal because at the time, immigration law did not exist the way it does today. There wasn't really the notion of deportation. That didn't really happen, right? You didn't really need permission to enter a country the same way you would today if you are at peace. If you're at war, it's a belligerent, right? But for peace, it's not. But I want to talk about the Sedition Acts, right? Noel, walk me through.
So the idea is that in the time that the Sedition Acts were implemented, you had fear of the state infringing, or you have fear that the state was going to come on to the personal rights of people.
Mm-hmm. That's very good. Noel, let me ask you another question. Why did Congress enact the Sedition Act? What was the purpose behind these laws?
Well, because I guess in the time of Wilson.
No, I'm talking about in the 1790s. Wait, not the Espionage Act. The Espionage Act was in 1917. I'm talking about the Sedition Act passed during the Adams administration.
It was the Federalists.
Jonathan? Are you John now?
Yeah.
Are you going by John?
I'll go by both. So I think we just watched the first version of the Constitution fail. We're trying the second version of the Federation, and it's kind of a baby, and we want to protect it.
Uh-huh.
And so I think they passed this, so it's like, well, let's not have another revolution.
What were they afraid of? What were the Federalists afraid of? Noel's right. This was a Federalist legislation. But what were the Federalists afraid of?
What do you mean?
Why did they pass this law, the Sedition Act? What were they afraid
They didn't
of?
want people talking crud about the Congress.
Because what could happen if people were talking crud?
They'd start rebelling.
There it is. Okay. So I want to give a qualified defense of the Sedition Act. I'm not defending it, but I want to explain what was in their minds. We had just fought a bloody revolution. We had the Articles of Confederation. It was a flop. Right? We had this new Constitution, not even a decade old at this point. And there were fears, whether they were credible or not, I'll let you judge, that our nation was on a shaky footing, that there was foreign intrigue, that foreign nations were trying to infiltrate the highest ranks of our government, and that they were trying to subvert our nation and entangle us in wars in Europe that we wanted nothing to do with. This was George Washington's famous neutrality proclamation. I do not want to deal with all these European problems. And then you had Thomas Jefferson, who was the vice president to Adams. They hated each other. Jefferson was a Francophile. He loved France. He spent many years there as an ambassador. He was there when the Constitution was being drafted. And Jefferson showed a very strong affinity for the French Revolution. He saw the French Revolution as a mirror of the American Revolution that will lead to similar places. And people started getting their heads chopped off. It was a disaster, right? But, Jefferson was a Francophile. And the Federalists were afraid that if we allow this sort of sedition, this sort of treason in our nation, we will be no different than Europe, right? Our republic will falter. So, I say this as with just a qualification. Their hearts were in the right place, right? But now, Ryan, let me ask you this question. The Sedition Act, as I'll call him John now, as John describes it, was to prevent people from talking crud about the government. How does stopping people from speaking crud about the Republic save the Republic? What's the linkage? Let's just a means end, right? What's the linkage there?
It kind of disallows it from manifesting throughout the rest of the country. So, if people are allowed to speak it, then it won't kind of gain traction.
Oh, okay. So does it stop people from believing this stuff, right?
No, it stops more of the widespread kind of.
So what happens, Ryan, if you have an idea, but you can't talk about it in public? What does that do to you?
Probably makes you rebel even more.
Well, yes, you're right. But when you have an idea and you don't know if anyone else has that same idea, what does it do to you? How does it make you feel? Imagine before. Yeah, alienation. Very good, right? The idea is this, that if we stop people from thinking about these ideas publicly, then it'll just be ideas in someone's head, right? And if it's just in your head, you think maybe you're the only one who thinks that the King George is a traitor, or he's a tyrant, or that the Federalist Party is dangerous. So the thinking behind censorship is always, if we allow this information out, it will spread, and people might find it persuasive. People might find this information useful. People might find this information compelling. People might find this information so compelling that it pushes them to take action, right? Not only are they writing pamphlets, they might get a musket, right? They might start bearing arms for some cause. They might actually do something about it. So at all junctures throughout all of American history and all world history, the basis of censorship is if you stop people from speaking about it, it will mitigate any harm that may result from it. Now, I think Ryan said this a minute ago, does this sort of thing actually work? No, it usually backfires, right? I don't need to take a poll on this one, but as a general matter, if you tell someone, don't talk about this, what do they want to do? Talk about it more, right? They're going to talk about it more because, well, maybe I should be, it's a fear of the forbidden. If something's forbidden, you tell the kid, don't touch the cookie, they're going to touch the cookie. So the Sedition Act, let me just walk you through it. It made it a crime to oppose the government of the United States. It made it a crime to impede the operation of U.S. laws. And this didn't just mean, like beating up a federal tax collector, right? I think we all agree that if, people are beating up federal tax collectors, whatever, that's a bad thing. But it was a crime to write, print, utter, publish any false, scandalous, and malicious writings with the intent to defame or bring the government to contempt or disrepute. Okay? Now, think back to your torts, right? You guys did New York Times against Sullivan, about the criticism of public officials, right? Think about Sullivan here. Under a modern law, can you be criticized for spreading a false fact about a government official? Maybe, if you have the right state of mind, you have to have actual malice. Remember from torts from 1L. But here, it's not only false statements. It's scandalous, malicious. Bring them in contempt and disrepute. So you can give a statement that's completely accurate, 100% accurate, and that's a crime. You can give a statement that's maybe 75% accurate, or 50% truthy, right? You're not really sure, maybe it's a rumor, scandalous, malicious, right? and you can be thrown in prison. Now, on its face, this law seems pretty open-ended. And it gave the Federalist Party a lot of discretion to prosecute. And it's a fact of history that who did the Federalists prosecute? Their opponents. They prosecuted members of what we now call, well, it was the Republican Party, right? The Jeffersonians. And lots of these people were thrown in jail. Did these individuals say, hey, you can't throw me in jail, the First Amendment? Oh, sure they did. And the judges who were Federalists approved the charges. There's this one note in your book, which Randy put in there, it's funny. He says, Justice Chase would apparently, this is different than Salmon Chase, they're not related. This is Justice, a different Chase. It's actually Samuel Chase, even more confusing. There's Salmon Chase was Lincoln's Chief Justice, and this is Samuel Chase, who was a Federalist judge. So you get them straight. He apparently was laughing and screaming at the various defendants because he thought it was funny. So there were these prosecutions, and you had all these Republicans being thrown in jail. Now, they didn't get any relief from the court, but you know where they got relief from? Politics. One of the reasons why John Adams lost was because he became very unpopular. And a lot of the popularity was due to the Sedition Act, right? When you try and censor stuff, it almost always will backfire because people realize what's going on. This is a bad idea. Now, I'll come back to the Virginia and Kentucky resolutions in a minute, but I want to focus on this point for a second. What's the relevance of the fact that in the earliest years of a republic, right, 10 years after the Constitution was ratified, Congress passed a law that bans political speech? When we're trying to be originalists, right, and saying, what does a freedom of speech mean? Do we say, we look at early practice? Maybe like Noel Canning, you might recall that case, at the Reese's appointments. JC, what weight do we give the practices of the early Congress in the 1790s, which banned political speech? Should that inform how we understand the freedom of speech today?
I think at this point it's kind of swept under the rug.
Oh, I like how you put that. What do you mean?
You hear cases today and they talk about, well, we can't regulate this political speech, we can't do this, but then apparently, I didn't even know this happened.
Yeah.
And then in the founding years, people were actually sent to jail for doing the exact same thing because they opposed the party in power.
Yeah. Yeah. So, Alicia, is it Alicia? How do you pronounce it?
Alicia.
Alicia, thank you. Alicia, let me ask you this question. But if we try to understand the freedom of speech as an original matter, what did that phrase mean in the 1790s? Do we just look to the Adams administration and just stop there? Is that all we can look to?
You mean today?
Yeah, if we're originalists today, we're looking back at the Constitution in the 1790s. We stop, say, John Adams, that's it, that's the meaning.
I don't believe so. I think we would go even further than that.
Oh, tell me where.
Perhaps. I think we would even go back as far as the Magna Carta.
Okay. What do we find in Magna Carta?
Well, that it was like Madison wrote, where it was the document that regulated what the king could and could not do.
Very good. Now, Alicia, you mentioned Madison, right?
Correct.
Was the John Adams approach the only philosophy in town at the time?
No, it was not.
Who else was there?
Well, there were the Jeffersonians.
So Carl, let me ask this question, right? We have, again, two streams of authority. Go back to McCulloch, right? You had Hamilton said the bank's A-OK, right? And then you had Jefferson saying bank is no good. Supreme Court went with Hamilton. So Hamilton won the day there. Did the Supreme Court ever adopt an opinion about the Sedition Act back in the 1790s?
I don't believe so.
No. So if we're originalists today, right, are we bound by either the Adams or the Jefferson? I mean, is one or the other better or worse for us?
No.
Why not?
Because, I mean, the idea is that you're not strapped to one idea, you can think outside of those ideas.
Yeah, oh good, now you're getting where I want to go. So Dyer, let me ask this question, right? So Carl says we can think outside. Now, on the one hand, we have legislation. We have the Sedition Act passed Congress, went through both houses, right? How do we know what the other perspective was? What tells us the other perspective was? We have legislation with the Adams opinion. There were prosecutions. We have federal judges who rubber stamped them. What tells us what the other perspective was?
The acts from the states, Virginia and Kentucky.
Bingo. Why were those important, Dyer?
I don't know, because since they censored the press, they had
Yes.
published them through acts and
Very good.
Congresses.
Very, very good, very good. This is a point which I'll probably repeat ad nauseum. The courts do not have a monopoly on interpreting the Constitution. I've said it 100 times. And perhaps that's nowhere more true than with free speech in the 1790s. Because you have these two spheres of authority, right? You have the Sedition Act that was passed by Congress, signed by President Adams. You have all these prosecutions by these federal prosecutors, right? But then you have the other authority. You have the legislation by the states. You have the Kentucky resolution, and you have the Virginia resolution, right? These resolutions did a lot. We'll go through them in a minute. But at a minimum, they articulated that not everyone agreed with the constitutional philosophy of President Adams. That the states, which have an important role in our republic, said, we disagree. And we seek the approval of other states who may or may not agree with us. What does this remind you of? This is a hard question. Let's see if anyone got this one. What do the Kentucky and Virginia resolutions remind you of an important document you've read in the past? I have a hint if no one gets it right away. And I'll give you the hint is the author, right? The author of one of these resolutions authored this other document. That's your hint.
Declaration of Independence.
Why? Why? What was the Declaration of Independence?
Saying that they had a duty, right.
Yes, but what was what kind of document was the Declaration? What was it meant to convey? To whom? To whom? Who are they trying to talk to? Not the nations of the world. Yeah. Yeah, I mean, it's in your book. I didn't think I flipped to it, but we can go to it, right? Right? Where is it? Page. Yeah. Yeah, page 15, right? And then the paragraph. To prove this, let facts be submitted to a candid world, right? This was basically a memo, an open-ended memo, if you will, right? The Declaration was designed not just to talk to the Brits, it was meant to talk to them, but it was a declaration to the entire world saying, we got these problems. We hope you agree with us. And when I was reading the Virginia and Kentucky resolutions this weekend, I was struck at the similarity. It's saying, hey, we have this tyrant at home, right? He's doing bad stuff. His name is John Adams. He's ignoring our fundamental laws, our free speech rights, right? We're not calling for revolution yet, right? We're not there yet. These are not light, maybe light and transient causes, if you will. But we want other states to agree with us, right? We're going to write these resolutions and share them with the executives of all the other states in the Union. And you know what? If enough of them agree with our opinions, then maybe we'll have an election and these stupid laws will be dissolved. And in fact, they sunsetted. They didn't survive the election. They were not renewed. So again, the resolutions from Kentucky and Virginia, I think, have to be understood in this context. There was no free press. Had these things been published as a pamphlet, they probably would have been criminal, right? They could have been prosecuted. I don't think they tried to criminalize the state legislatures. I suppose they could have. But if these had been published as a pamphlet, the guys would have been thrown in prison for criticizing the law. But it was done to suggest an alternate constitutional philosophy. And there's this word in the Virginia resolution by Jefferson, right? Interpose, right? He says, the states have the duty to interpose for arresting the progress of the evil. And this phrase interpose is not a common phrase that we use nowadays. I don't think the dictionary gets it across. But I think the way I read it, the best way of reading it, is that the Virginia resolution was trying to assert the rights that the states had against the federal government and share that opinion with the other states for the purpose of shining a light that there was an alternate constitutional philosophy, right? These documents illustrate what it means to interpret the Constitution outside the courts. This was not a SCOTUS opinion. It was not from the Supreme Court. It wasn't from John Marshall. John Marshall, by the way, first day of class hating on Marshall already, right? John Marshall actually presided over a prosecution under the Sedition Act. He approved it. He didn't dismiss the charges. He could have found it was he didn't. He was writing what's called a circuit justice. He was in the lower courts. But this is about interposition. Okay? So let's walk through the Virginia resolution for a bit. Was it Witt? I remember like most of your names. I might screw up a couple times, but depends how far you had me. Maybe 2 or 3 years. It fades a little bit. I'll try my best. So Witt, walk me through the Virginia resolution, which was, we know Jefferson wrote it. He never actually took credit for it, so I'll just like hesitate a little bit, but it was Jefferson. And if you read it and compare it to the Declaration, there's a lot of similar phrases, like, you know, we have a firm resolution to maintain the Constitution. We're duty bound. It's a very, very similar tenor to the Declaration, because this is, I think, how Jefferson thought of the world. So what, want to give me the, just walk, not facts, but just walk me through the Virginia resolution, please.
Yeah, he starts off by kind of avowing his loyalty to the Union, or Virginia's loyalty to the Union.
Why is that important? That's a very important move that he does. Why is that important, that he avows his loyalty to the Union?
Yeah, and I think it's noted in both of these, like the very first thing, and I think because they knew the nation was so young, for them as an entire state to take a stance directly against the federal government could be misconstrued as like wanting to rebel.
Yeah.
They did not want that.
Yeah, exactly, yeah. He, did you guys get the name tags? Here, I'll bring them over for you. And who has the marker? Just send it this way. Yeah, I'll bring it over later. Right, so I think it's important that, here, I'll get it. It'll be quicker this way. Yeah, excuse me. I'll give it to them, right? So I think it's important to stress that this is a young country, and they were not basically saying we're throwing out the entire damn thing, right? We think this is going to work. The laws are fine. They're not being faithfully executed by the Adams administration. And then we get to this idea of interposition. Often, when people describe the Virginia and Kentucky resolutions, they say it's about nullification. And this is a word with a very loaded context, right? What's nullification? Nullification is the idea that a state can basically disregard an unconstitutional law. Right? Now, we know from the Supremacy Clause that federal laws are the supreme law of the land. But what if a law is unconstitutional? Is it the supreme law of the land? Does the judiciary have the power to disregard an unconstitutional law? We generally accept that. Do the states? Well, this was a major fight during the days of slavery. And most famously, South Carolina, yeah. John C. Calhoun, a senator from, I think, South Carolina, articulated that federal tariffs on agriculture, which the southern states hated, were unconstitutional and they could be ignored. And this was a great nullification debate. I'm not going there now. Maybe we can talk about nullification another day. But I think the Jefferson and the Madison positions are different. They were not saying that the federal statute can simply be ignored. I think what they were trying to do is articulate why it was wrong and speaking to a common opinion, right? And that's the purpose of interposition. Now, Madison in the Kentucky resolution did use the word nullification, although I don't think he quite used it in the same way that Calhoun did. All right, Colby, thank you. Perfect timing, look at that. Colby, let me ask you a question. Why did Jefferson think in the Virginia resolution that the Sedition Acts were unlawful? What's his argument?
They were not specific, they can't punish crimes not specifically delegated to the Constitution.
Yeah. Were you all surprised by their grievance? Right? Did you all expect, oh my God, there's a freedom of speech thing? No. The argument was based on structure, right? They said Congress does not have the power. Looks like you're doing a joint with that.
Oh, no.
Oh God. Oh God. Congress does not have the power to enact this laws. And on the Alien Act was more specific. The president can't deport people unilaterally. The argument was structural, right? We'll do that when we get back to race, right? The argument was more structural. They said that there's no federal power, and the federal government exceeded its bounds. Okay. And at the end, Jefferson writes, this is not nullifying, right? We're sending copies to the other governors, the other executive authorities, and we hope that they agree with us. Because you know what? The states were represented in Congress. The states selected the senators, as you recall. And I'll tell you what, the states were not going to send more senators who would support things like the Sedition Act. And members of Congress had to be reelected. And I'll tell you what, if you support the Sedition Act, you're not going back to Congress. And that's exactly what happened. The Federalist Party died in 1800. It just died. Like it never came back to prominence. In large part because of this law. And their last-ditch effort to preserve their power was actually the Midnight Judges Act, right? Which Jefferson also killed. They tried to get their judges at the last minute. Now, a fun footnote, I'll get to Madison in a minute, but after the election of 1800 and Jefferson was sworn in, the Sedition Act sunsetted. It expired on its own terms. Jefferson pardoned all the people convicted under the law. And in fact, the Republicans paid whatever fines, criminal penalties were assessed. When we're assessing constitutional meaning, we have different authorities. We have Adams saying this is constitutional, and you have Jefferson pardoning all the people. What does that tell us, right? That even in the 1800s there was a disagreement about this law. Today, I think JC said swept under the rug is a good expression. The Supreme Court has said that the Sedition Acts have not stood the test of time. I think that's probably right. All right, so now we have the Kentucky Resolution by James Madison. It's very similar, although it uses the word nullification. Jesse, let me ask you this question. In the Kentucky Resolution, it's fairly short. Madison's worried about this silent acquiescence. What's he talking about there? What's this phrase acquiescence mean? What are they worried about? What's Madison worried about with this acquiescence? What does acquiesce mean, just as a general matter?
Not sure that I'm thinking about this properly, but sort of like being complacent.
Yeah, complacent, very good, right? So let me ask you this question, Jesse. What would happen if the states were complacent? That they just accepted the Sedition Act and they didn't do these sort of resolutions, right? What's our signal would that send? What message would that convey? Bingo. And that's why they wrote it. Yeah, John, 1 second, I'll get you. Madison's saying that if they sit there in their butts and do nothing, it's conceding. It's saying, okay, Adams, you're right about the Constitution. That the purpose of these was to articulate a dissent, if you will, a minority report, right? This is not the way things go. John?
I thought Jefferson wrote Kentucky and Madison wrote Virginia.
Did I flip it?
I think you did.
Oh, crap.
It says on 1304.
I did. I'm sorry. Okay, I flipped. I'm sorry. Which is the right one?
Jefferson did Kentucky, Madison did Virginia.
Madison did Virginia. You are right. I put in my notes backwards. Okay, my bad. Screwed up on day number 1.
So were we discussing really Virginia first or Kentucky first?
No. I did Virginia first, just so it was Madison. But I do think that there's similarities with the Declaration. I screwed up. Damn it. Oh well. Yeah. Is there a hand?
Oh, no, sir.
Okay, thanks, John. I appreciate it. Always call me out when I'm wrong, because I do make mistakes. I do. Yeah. At the time, Kentucky was a fairly new state, and it was basically formed as an outcrop of Virginia. So there were a lot of shared sympathies between the two commonwealths. Damn it. Yeah. Thank you, though. Okay. All right. So are there any questions other than my screw-up at which one was Madison, which was Jefferson, the Kentucky and Virginia resolutions? Any questions about these? Okay. So after the election of 1800, Madison, who was then the Secretary of State, like Marbury versus Madison, he puts out a report that defends the Virginia Resolution, which he wrote, right? And he argues that this was a valid statement. Now, it's very rare that a high-ranking government official says, we don't have the power to do something, right? Usually government says, we want all the power we can get. And whatever power my predecessor used, I want that power plus one. That's the general trajectory of executive, I didn't do that on purpose, but it was the general trajectory of executive power. It grows and grows and grows. But Madison's doing the exact opposite. He's saying Congress does not have a police power. They have only the enumerated powers, and they can't enact this law. So again, you have different constitutional theories. You have one government saying it's constitutional, and you have another one saying it's not, without any judicial resolution. And then Madison conveys these two theories of the First Amendment, which I think I alluded to earlier. The British focus on prior restraints, and the American theory, which says that you can't punch before or after the fact. And he explains why we're not like the Brits. And this is actually an important point. In England, the freedom of speech ran against the king, right? The king could not punish you for criticizing the crown. But you could not criticize Parliament, the legislature. In England, the Parliament had unlimited power. They could do whatever they wanted. And it was viewed that the Parliament were of the people. That theory, though, doesn't work here, right? Because Congress does not have unlimited power. They have only the powers that are enumerated in the Constitution. Look at Madison's opinion on the federal bank. So here in the United States, the people possess the absolute sovereignty. All branches of government are bound by the Constitution, not only the executive. So Madison writes that the British system simply can't apply to the United States. Okay? And then Madison writes, if we had the sort of Sedition Act that was in effect in 1799, we would still be a sickly confederation. We would have never made it out of the Constitutional Convention. Think about it. If the Sedition Act was in effect in the 1780s, the Constitutional Convention would have been illegal. Why? They were criticizing the convention, the Articles of Confederation, right? The very nature of our Constitution came about as a criticism, saying that this other document sucks, we need a new one. And then Madison writes, we would still be miserable colonies groaning under a foreign yoke if we couldn't criticize the king. Indeed, when the Supreme Court said that the Sedition Acts were unconstitutional, they looked to Madison, said Madison was right, not Adams. Okay? And then Madison makes another point. To Joyce, let me ask you this question. Here's a criticism, right? Only the courts can find that the Sedition Acts violate the Constitution. How does Madison respond to that argument? Is there anything improper about the states declaring a law they think is unconstitutional?
Because it would be different from like the court declaring it.
Good. Good. What's the difference, Joyce, between a court saying a law is unconstitutional versus a state putting out these resolutions? There's a difference.
I guess if the court says it was unconstitutional, then it would have to be followed by everyone.
Good.
And then if the state did it, it would be per state.
Very close, very close. I'll say it like this, right? When the court issues a ruling, Madison writes, it's immediately carried into force. Now, I know that's not actually true, and we know that people ignore court judgments all the time, so I'm just going to put that aside, right? But in theory, at least, right? When a court says stop, people are supposed to stop. But when a state expresses a sentiment, it's about changing general will and changing opinion. So the state's resolution was not actually about stopping a law, but expressing a mere opinion, which is, I think, at the core of the freedom of speech. And even Madison describes the states as guardians of liberty, and they serve as a buffer between the people and the government. And he cites the 10th Amendment for this proposition, that the states have a role in preserving the freedoms of the people, not just in the courts, but also in the political sphere. Okay. Questions about the Sedition Act or the Alien Acts or Madison or Jefferson and Kentucky and Virginia? I'll get this right next year, I promise. Oh, damn it. Questions? Nothing? Okay, so we'll move on. We started our class talking about the year 1800, and our next case in the year 1919. You may ask, Josh, what the hell, right? What the hell? What happened for 100 years? And the answer is basically nothing. And the answer is nothing for a couple reasons, right? First off, Congress didn't really pass any laws about speech. Didn't really come up, right? The federal government was fairly weak and feckless for most of the 19th century until the Civil War.
But didn't they do that one German case where they couldn't teach German, but they did it under?
That was in 1920. Yeah, that's Meyer. And that was a state law also. But until the Civil War, the federal government didn't really do that much. So there weren't many occasions to have free speech prosecutions. The other element is that, excuse me, the First Amendment was only understood to limit federal power. Barron v. Baltimore, right? The Bill of Rights did not control the states. So the states could shut down newspapers all they wanted. Okay, then we get to the Civil War. And you might remember a case we studied called United States versus Crookshank. This was an awful, awful case, my goodness. What were the facts of that case? You had a lynch mob, burned alive an entire church full of African-American militia members, burned them alive. And indictments were brought under federal law saying that the militia, the mob, burned them in violation of their rights to associate under the First Amendment and the right to bear arms under the Second Amendment. And in Crookshank, the court held that no, the 14th Amendment did not change the calculus. The Bill of Rights did not apply to the states. So that was a huge First Amendment case that wasn't, because they said that First Amendment's irrelevant.
I was wondering, do we know if there's any time where like a senator like said, hey, Virginia, I'd appreciate it if you shut those fellows down? Like that from a press, do you see the states could?
Are you talking about in Crookshank?
No, I mean, so like you're saying how, like how the freedom of speech dealt with the feds.
Right.
But states could shut down press.
Oh, you're saying a federal official tried to enlist the state to censor the press?
Yeah.
Well, that's a good question. I don't know. I'm sure it happened. The states did enact pretty stringent restrictions on speech all the time. But then we fast forward to World War I, which is basically the basis for, I think, the first 3 or 4 cases for today. Not all the cases are this short. I know you enjoyed them, but these are fairly short excerpts. And we have several decisions decided in a fairly short span. In 1919, we have Schenck v. U.S., Debs versus U.S., and Abrams versus U.S., all decided in the span of 1 year. And each of these cases arose from the Espionage Act of 1917. The Espionage Act was passed during World War I, and it was basically a means to silence critics. And it silenced them in a very specific fashion. At the time, the United States had a draft, a military draft. It was basically a lottery, and everyone got a number, and depending what your number is, you were put in a drawing. And if you drew the right number, you'd be put in the service for military. You'd be sent overseas, to Germany, to France. The death rate was very high. It was a very, very bloody war with poisonous gas and trenches. It was awful. Did anyone see that movie by Peter Jackson, They will not be forgotten. There was a movie recently where they took this World War I footage and they colorized it. And they added sound to it. What would it sound like? By Peter Jackson, the Lord of the Rings guy. I didn't see it, but I wanted to. At the same time, in 1917, there was a big movement going on, which was socialism. Right? In Russia, in 1917, you had the Soviet Revolution, where you had the Tsar was deposed, and you had the Leninites and the Trotskyites, all that stuff, right? There was a fear in the United States that these socialists, these communists, would disrupt our republic. The exact same types of fears about the French in the 1800s, that this foreign power would interrupt and obstruct our government. And they would obstruct the draft. They would cause labor strikes, which would disrupt supplies of materials needed for the war. Think of Youngstown, right? That these forces would make it impossible for a republic to stand. So Congress enacted the Espionage Act. And they mounted prosecutions against Schenck, against Eugene Debs, and against Abrams, and a lot others. We only gave you 3 of these cases. There are a lot more, which we didn't give you, Frowork and others. And all the cases had the same idea. These individuals were giving speeches, distributing pamphlets, handing out newspapers, magazines that were critical of the government, critical of the draft, critical of American labor policy. Okay, now here's the important point. These documents weren't only designed to express their opinions. We can be candid about this. These pamphlets, these speeches were designed to motivate people to action. In fact, most writings are, right? Read any newspaper op-ed, full tweet, right? Whatever you want to read. Generally, people put stuff out, not because they think it's a good idea, but because they want people to agree with them and take some action based on it. That's the nature of human interaction, right? We speak to someone in the hopes that they'll agree with us and do what we say. So let's say I'm giving a speech, and I'm saying that the draft is immoral. The draft is unconstitutional, violates the 13th Amendment, slavery. Am I just saying this because I'm giving your opinion? Or am I trying to say, wink, wink, nod, nod, you should not go to the draft board. You should ignore the draft card. Or if I say, American labor policy is immoral, right? The poor people are being suffered to work in these factories for low wages, and it's immoral that you're being forced to build munitions which are being used to kill innocent people. Did I say, go on strike? Don't build these munitions? No. But what is the effect or the tendency of my speech? Probably to make people stop working. It's like, wow, I didn't think of it like that, Josh. That's a good, damn it, I'm not building more munitions, not building more bombs. That's right, Josh, good for you, right? This is what was known as the bad tendency test, right? The bad tendency test, right? The idea was if your speech had a tendency to not just express an opinion, but cause some other crime, such as going on strike, which was a crime, or to cause dodging the draft, which was a crime, right? If your speech had this tendency to cause other bad stuff, then the state could punish you for it, even if you were just giving a speech. And if you notice in all the opinions, they were very careful about this. They say, well, we're not upholding the prosecution because he was giving opinions, right? In every opinion, they were very careful on this point. They were not punishing for just having socialist opinions. I think Holmes said this is like, puny, whatever, these stupid ideas, right? He's even dragging the guy's beliefs, right? But he says, if they go beyond this line, this bad tendency to promote. So the question becomes to the court in Debs and Schenck and Abrams, how close, how tight is the fit between the speech at issue and the bad thing, right? Is it very attenuated, or is there a pretty direct link, or what Holmes would call clear and present danger, right? Not just a Tom Clancy movie, right? Is there a clear and present danger that this speech will have, if I can use from torts, a proximate cause? If this speech will have a bad tendency, will have a proximate cause on engaging in some criminal activity, then the state has the wherewithal to. Yeah, Nathan.
So just to be clear, clear and present danger test is the bad tendency.
Yeah. I mean, Holmes didn't say it directly, but that's generally how it's understood. Yeah.
So, clear and present danger, I just want to clarify, because
We'll get to the case in a minute, but go ahead.
Is it the threshold for the bad tendency?
The clear and present danger measures how bad the tendency is, right? How strong the tendency is to lead to the bad event, right? Because if, say it's like, I'll give you an example. If I publish in my diary that no one's going to read, that workers of the world unite, U.S. government must fall, and this is in my diary, it's locked away in my drawer, is there any sort of risk that can cause people to dodge the draft and go on strike? No, it's in my diary, no one's going to read it. If I circulate 20,000 pamphlets and hand them out on street corners near the drafting office, that's probably a different story, right? It's how clear and present is it now, or is it maybe at some point in the future? Right? Holmes says in Abrams it's a matter of degree, right? How much of a proximate cause is there? Is there intervening causes? Is it unlikely? All right. So Andrew, you want to give me the facts, please, in the first case, Schenck?
Yes. So you said the Espionage Act was enacted in World War I. We had Schenck, and he would mail out little leaflets or pamphlets to draftees, really criticizing the draft, pretty much stuff you just said.
He even said it was unconstitutional in the 13th Amendment, which is a non-trivial argument.
And so he was convicted. He was tried and convicted for trying to cause insubordination in the military and obstruct military recruitment. That was kind of the reasoning of what he was doing.
Yeah.
Obviously, he was convicted. He lost the appeal, went to the Supreme Court, and they again said, no, your conviction's going to stand.
Yeah, very good. So Holmes gives this version of the test. He says, whether the natural and probable tendency and effect of a publication are such as are calculated to produce the result condemned by the statute. So this is saying, is the probable effect of the speech to cause people to obstruct the draft? Yes. Therefore, it can be censored. And then he says, when a nation's at war, many things that might be said in times of peace are no longer protected. I mean, this is, if you took me for common law, I had the maxim, in the times of law, the wars fall silent. And this is a pretty express statement of that maxim, yeah? That if this was a time of peace, that this wouldn't fly, but in times of war, it's justified. Why? Because the bad tendencies are pretty bad. Holmes also gives this famous test, which is always misquoted. The fire in the theater. Everyone says it's wrong. It drives me bonkers. I criticize people on TV whenever I'm on radio. I was like, that's not the quote. It's falsely. Anyway, Holmes says, the most stringent protection of a free speech would not protect a man in falsely shouting fire in a theater and causing a panic. Falsely, right? If there's actually a fire, you can shout fire. Anyway, put that aside. Fast forward, this is no longer good law, right? All these cases, Debs, Abrams, Schenck, it's not good law anymore. We mentioned this, I think, later in the reading. But now you have to have what's called an imminent incitement to violence, right? It's not just a probable tendency for violence. It has to be imminent, like right now. So don't use these cases as a statement of current law. But if you remember anything from my exams, I will always ask a question at some point in the past, and this is a good starting point for a question. I haven't thought about it yet, but this might be a good starting point. So any questions on Schenck? Yeah, Cameron.
When justices do that about the wartime stuff,
Mm.
when you then interpret the law, though, does that come into play?
I'm sorry, say it again?
Like when it comes to enforcing how this Espionage Act is treated, or just any act, where you say, well, in wartime, we view it this way. Well, when wartime is over, that
Yeah.
that ruling is still on saying that this is enforced.
Yeah, I mean, this is, if you remember Korematsu, Justice Jackson described the decision as a loaded gun that will sit around for some point in the future, right? It's very difficult to limit an opinion to wartime. It doesn't really work.
Yeah.
But yeah, good point. Anyone else on Schenck? Okay. Yeah, okay, Dyer.
You said that there was more cases here. Were all of the people convicted socialists?
Just about. Yeah, they're almost all socialists. I mean, socialists, anarchists, you know, the entire gamut of the spectrum.
But if you had said the same thing as a pacifist for religious purposes, and said the draft was unconstitutional, you should avoid the draft, would they have been able to convict you at the same time because it's not for a foreign power there in espionage?
Well, it wasn't just because they were foreign power for Russia. The anarchists were against all government. So I don't think it would have mattered. And in fact, in the 1920s, the free exercise clause basically had no teeth. And I don't think it would have made a difference. We'll do the free exercise clause halfway through the semester. I don't think it would have made a difference.
So what was the point of these courts, especially all within the same year here, granting certiorari to very similar cases that all ended up the same?
They were all slightly different, right? If you look at the facts, some involve pamphlets, some involve speeches, right? Some involve mailing. They basically wanted to hit one of each, right? All the possible ways that people could resist the draft, they wanted to hit. And that way they wouldn't have any lower courts saying, oh, well, this case might be a little different, we'll reverse the conviction. But yeah, that's a good point. I mean, they all had similar but slightly different facts. Okay, other questions on Schenck? And if you just go to Wikipedia, I know it's not a good source, but they actually have the original pamphlet that Schenck distributed. It's in high resolution, and you can read it. I mean, you know, it's his opinion, but they're very careful not to actually advocate that people should obstruct the draft. He's like, what are you going to do about it? Huh? But they stop short, right? It's like, what are you going to do? Huh? Yeah. Anyway. But Holmes's test is very broad. If there's a probable tendency, that's enough for the state to, or I keep saying state, the feds to punish. Okay. Any other question on Schenck? Oh my goodness, I can't read that. Harrison, you got to get a marker. I can't read that. Yeah, send him the mark. Where's the marker? I have another one. Oh my God, it's like pen. Okay, I remember your name, but it's gonna be very hard to see that from a distance. I didn't have glasses when I started teaching. Now I do, and they keep getting higher and higher prescriptions. So Harrison, let's talk about Eugene Debs. Is a fascinating figure. He was a socialist. He ran for president, I think, 5 times. He got nearly 6% of the popular vote in 12. In 1920, he ran for president while in prison. I didn't know you could do that, but apparently you can. He was actually released and pardoned. Was it by Coolidge or Harding? Harding, thank you. Very good. You knew that? Very good. Yeah, he was pardoned by Harding. It was a huge, actually, give me the sentence and pardon, but it was a huge deal because this was a very controversial figure. So, Harrison, walk me through the facts, please, in Debs.
So yeah, Debs was indicted, or yeah, he was the leader of the Socialist Party, and he was indicted for.
And that's the Socialist Party of the United States. It's not like a Soviet. He was actually, you know, the Democrats, Republicans, the Greens. He was a socialist, right? That was the party. Go ahead.
And he gave a speech that basically talked about it was offering support for others who were arrested for.
Very good.
Yeah, for aiding and abetting in others' families registered in the draft. And he was indicted for the inciting disloyalty, meaning basically people thought, or convincing people not to join the draft.
Very good. I want to find this and play it for you. There's a speech of Bernie Sanders reading the Eugene Debs speech. I just want to play a few seconds of it. Just give me clear and present danger. It's just I want to play a little bit so you get the flavor. But Bernie's reading it. Where is it? Okay, here it is. 222. Just you have to no visual. Just listen to my computer. And if the socialists send me a takedown notice, that'll be very fitting.
Has has ever been declared by the people. And here let me emphasize the fact, and it cannot be repeated too often, that the working class who fight all the battles, the working class who make the supreme sacrifices, the working class who freely shed their blood and furnish the corpses, have never yet had a voice in either declaring war or making peace. It is the ruling class that invariably does both. They alone declare war, and they alone make peace.
Okay. So that gives you a flavor, right? Now, again, Debs was, perhaps a little bit less circumspect. He was encouraging people to obstruct and resist the draft, right? He was saying that this is a war fought by the ruling class, that they're using your body as a corpse, that no person of the working class ever waged a war, that this is immoral. He also praised several of his comrades who were convicted of aiding and abetting failing to register for the draft. He praised people for the loyalty to socialism. He praised people who obstructed the military forces. And he says, you need to know that you are fit for something better than slavery and cannon fodder. He told the people, don't worry about the charge of treason to your masters, but be concerned about the treason that involves yourself. Yeah, right? So he, I think, probably, whatever the line is, he probably crossed it, right? And he knew what he was doing, right? This is not like a impromptu speech. He wrote it down, it was prepared, and he wanted to make a political point, martyr himself. The guy went to jail for a number of years, and this is the case. He told the jury, I have been accused of obstructing the war. I admit it. I abhor war. I would oppose the war if I stood alone. And it was obvious that the purpose of his speech was to obstruct recruiting. All right. Katie, can you walk me through the Holmes opinion in Debs, please? It's very short.
So he was basically saying that the defendant wasn't convicted under the Espionage Act for just opposing the war in general, but that he was trying to obstruct recruiting.
Yeah.
I guess that's essentially what he was saying. And
Right.
I had to have, at the end, I underlined it, but it said unless the defendant had specific intent to obstruct recruiting service.
Yeah.
Otherwise he wouldn't be convicted.
Very good, right? Debs here was not being punished for his general beliefs and opinions, right? He's not being punished for those. He was being punished because his words tended to obstruct the recruiting, right? This is not just advocacy of opinions. The natural tendency of his words was to put a specific intent, Katie said it, a specific intent in the minds of those listening. But again, I ask you, why do people give speeches except to persuade, right? I don't just come here and talking because I want to hear myself speak. You speak to convey ideas that people might agree with. Or maybe feel that way, I don't know if you, but you all want to be here, so maybe that's a bad example. But generally people speak because they want to be understood and people want to accept their ideas. But Holmes was not bothered. He said this was resolved by Schenck. Therefore, Debs' conviction was upheld. And then we get to the next case. And there are a lot of theories about what happened, right? 8 months after Schenck and Debs were decided, we come to November of 1919. And we get Abrams. And here, Holmes was in dissent with Justice Brandeis, who is a very prominent progressive on the court. So what happened, right? What happened to Holmes? He, if you took me for common law, I'm not a Holmes fan, but he basically upheld every conceivable effort to restrict liberty imaginable, all of them, like sterilization, parents teaching their children, segregation. He just upheld everything, right? He never found a lot. Which one?
Wasn't it more so the fact that the people voted for it, so he felt like that was what they did?
Yeah, Holmes once said famously, thank you, JC, for reminding me. He said famously, people want to go to hell, and that's their choice. I'll help them get there. Right? So he believed in the majoritarian rule. He was not a libertarian at all. But, John's laughing. But on the issue of free speech, something clicked in him between the Abrams and between Debs and Abrams. And then one of the theories is he became enamored by the progressives and these sort of liberal writers who were in the New Republic who said, oh, Justice Holmes, you need to be more expansive of free speech. And there's some evidence that he actually shifted his opinion based on some of these writings from the progressives in the New Republic. I don't need to go down there, but he did change his opinion a little bit. And maybe not. We'll see. So, yeah, Alec, you want to give me the facts, please, in Abrams, please?
So, Abrams, 4 defendants
Yeah.
were brought on charges.
I think it was 5 defendants, but yeah, close enough.
Distributing leaflets.
Yeah.
And they were anywhere from like being rebellious and anti-war to preparing munitions. And
Well, they objected to factories making the munitions.
Yes.
Yeah.
And it was all for the Russian Revolution.
Yeah.
That was the intent behind it.
Yeah.
And
Well, specifically, what were they worried about? What were they worried about Americans doing in Russia? Just be a little more precise. They had a specific concern about Russia.
Just America sending troops to Russia.
And then what would the Russians have to do in turn?
Send troops to help America.
In which war?
The second one.
No. Which war? Thank you. Yeah, World War I. Thank you. So let me try and unpack this a little bit, right? The socialists in America were saying, don't send the military to the Soviet Union, right? They're this brand new country. They don't want to get entangled with this European war. Let them just be their own country. And that's important, right? They weren't objecting to the American involvement because they thought the American Act was bad. I'm sure they did. But their purpose was to prevent U.S. from entangling the Soviet Union in these foreign wars in Germany, right? But still, the majority said they can't do this. Oh, Gabe, marker him, Harris. I can't. Just in a minute. I know your name. I'll give it to Kelly and Ruth and down the line. But just, Gabe, let me ask you. Give me the majority opinion, please, in Abrams. What did I think Justice Clark, who I can't think of another opinion he wrote, man, pretty insignificant. I was thinking about it. I have to look it up. Justice Clark.
So basically, he went over the 4 counts.
Okay. And that's not Tom C. Clark. It's a I don't know what his first name was. Justice Hessen Clark. My goodness.
So in the first count, he basically used words like disloyal, abusive language, or what they were using in the packet.
Uh-huh.
He also highlighted all of them were born in Russia.
Okay.
And then they haven't applied for naturalization.
Okay.
Let's see, he also used words as far as like rebels, anarchists, and revolutionists.
What was, Gabe, let me ask you this question. What was the tendency of their speech, according to the majority? What was the tendency or the effect of their speech, Abrams? If you were reading one of the leaflets of these guys, right, how would you react to reading these leaflets? So again, let me ask the question. What's the tendency or what result would likely follow from these leaflets, according to the majority?
It will probably cause an action as far as updating the movement or the
Yeah, it would frustrate the war. It would lead to perhaps resistance in the draft. It would lead to maybe strikes. John, you look upset by that.
I just felt like it was so attenuated. Like the idea that these 5 idiots, which is basically what Holmes says,
Yeah.
that they would ever get you to stop making guns was so silly that it was ridiculous to even prosecute them. But the other cases, they were actually out there really preaching it and getting people to listen. So I don't feel like these guys had any traction. It seems like a silly case.
So you think it depends how much traction they're getting?
I think it's objective versus subjective. And I think objectively this was silly. The other ones subjectively maybe.
Yeah, Alicia?
I think it has to do with who's saying what, more than anything. I think it's who's doing the saying, who's speaking.
And by the way, these were published in Yiddish as well. These were also Jews. And there's a heavy anti-Semitism element there as well. Yiddish, if you don't know, is basically a variant of German that was very popular among European Jews. So, Kelly, why does Justice Holmes dissent here? Does he have second thoughts about Schenck and Debs? Does he want to go reverse those cases?
I don't think he goes to reverse them, but he says it's not enough. It doesn't meet the clear and evident.
Good. Why is the danger not present and immediate? Why is the danger different in the case of these leaflets?
I'd say it's not really, they're not preaching anti-US, just an anti-intervention and getting Russia involved.
Yeah. Holmes distinguishes in the facts real hard here, right? He leaves Schenck and Debs in place, although I think by this point, he probably had second thoughts about them. And we know from his writings he had second thoughts, right? But he says, there's no present danger here, right? That their purpose, their object, is to stop American intervention in Russia, not to impede the United States from carrying and prosecuting World War I. And from this is a very, very important distinction, right? It's about stopping American intervention. And he says the socialist creed, but he calls it ignorance and immaturity, right? He does not pull punches there. He says he's a bunch of idiots, right? But they have the right to say this. And then he introduces this very famous test, which you may have heard, which is called the Marketplace of Ideas test, right? Marketplace of Ideas test. And he says like this: the value of speech is whether it can persuade. Think back to John Adams, right? To prevent the crud, to use John's word, right? To prevent the crud from maybe stopping the Republic, he stopped people from saying crud. Did that work? Of course not. Speech is only valuable if people find it persuasive. If speech has no value, it'll be ignored. Look at most of the crap people write. No one cares about it. How many retweets have you gotten recently, right? Just kidding. But Twitter is actually an example of really crappy speech. It's a lot of retweets. I mean, there's an argument that social media inverts Holmes's theory, that the worst speech gets the most attention because it's the most outlandish. Like an egg gets 1 million, likes on Instagram, right? Whatever, right? But if you know what I'm talking about, you're a good person. But Holmes says, to allow opposition means you think the speech is impotent. But the best test of truth is the power of the thought to get itself accepted. The best test of the truth is the power of the thought to get accepted. He actually describes speech as if it was a free market, right? As if it were a free market. And you have the Federalists saying, we need to stop this speech. And you have the Republicans saying, we need to have this criticism. And who won? The Republicans won. Jefferson won. Now, here in World War I, you had the Americans saying, we have to fight this war. And you have the socialists. And they got, 5 or 6% of the vote? They never won, right? Maybe they're still here and running for president. I don't know. But they didn't win because their speech didn't persuade enough. But that's not the government's job to decide. And this idea of the marketplace of ideas is still so important in our discourse. It forms a basis for the thinking that more speech is better, that the way to decide what's best is to let people speak, right? Don't shout people down and boo them off stage, as it were. Have a counter-protest, right? Tell people why they're wrong. Don't heckle them and stop them from speaking. Ask them questions. And the Holmes approach here is very famous. I make fun of him a lot in con law, I guess two. But here I think he tapped a very important insight that to this day I think people stick with. So any questions on the Holmes opinion so far? Justice Holmes and Abrams, very, very important decision. Yeah, Nathan?
Well, this was written in a dissent. I'm assuming he was quoted many times.
Oh my goodness, yeah. I mean, if you want to quote Abrams, you're quoting from Holmes, you're not quoting from Justice Clark. Right? Clark, I think, was in the court for like 5 or 6 years. He was not a very influential guy. I'm sure he was, a big guy in his time, Supreme Court justice, but, Holmes was a giant. And this was towards the middle of his term. I think he resigned in 31 or 32. So he had to still another decade or so in the court. One note, though, now I can drag Holmes a bit. Oh, John.
No. So the first 3 cases are going to have bad law, and the last case is good?
Gitlow, yeah, I think the Stromberg case is a good one, yeah. Yeah, the first site. Yeah, Jesse.
I have a quick question. So when you're talking about the value of people that are persuaded, and that tweet is only valuable if people find it persuasive, where do you, how would he define that level of persuasion? Like, where would that, I guess, threshold be where, okay, this is...
Well, let me put it this way. Debs is running for president, right? That's one easy way to measure it. How many votes did he get? He got, like, no votes. He came in a distant, like, 3rd or 4th place. But he had, 5% of the popular votes. So, I mean, he had it. But let me make this point clear. It doesn't matter if it actually persuades. What Holmes said, it's important to let people try to persuade. Don't stop them from speaking. If someone wants to talk garbage and talk crap and say stupid things, let them, and people will ignore them. Which is, again, why Twitter perhaps inverts that methodology, because the person with the stupidest thing gets the most attention, usually, with the most retweets, right? Does that make sense?
Yeah.
Okay. But I do want to drag home just for a little bit, right? He says that this marketplace of ideas is the theory of the Constitution. My goodness, Ali, how you've come a long way, right? We know from his Lochner dissent, his most famous dissent. This should be his most famous dissent, not Lochner. Lochner dissent's crap, right? But from the Lochner dissent, he says that the Constitution does not enact Mr. Herbert Spencer Schultzful statics, right? So this raises a question, right? We can all praise Holmes's marketplace of ideas theory. Where does he get it from, right? How do we know what the theory of the Constitution is? We know the Constitution is meant for differing people of different opinions. Does it involve laissez-faire? Does it involve economic freedom? Does it involve marketplace of ideas? How is a judge to know what the theory of the Constitution is based on the words, the freedom of the press? How is a judge to know? Ruth, you want to take a stab? How's a judge to know? Holmes seems pretty certain here. He says, if that's the theory of the Constitution, suckers, right? That's it. You're wrong. And
Based on past interpretations.
What authority does he cite, Ruth? Does he cite any? Yeah, what authority is Holmes citing in his opinion? Yeah. So how do we know he's right? I mean, look, we have John Adams with one opinion. We have Jefferson and Madison with resolutions. Then 100 years later, we have Holmes. I don't know. I mean, Holmes, I think, won the day, but how do we know that that's the correct way of understanding the freedom of speech? He sort of just puts us out there. Yeah. Oh my goodness. He was the one who upheld sterilizations for incompetent women. This is our moral arbiter? Holmes? My goodness. He upheld the racial segregation. I mean, he upheld everything. He upheld grandfather clauses for voting. I mean, this guy was not a generous dude. So this question, I'm not picking on Ruth, so I think he gave me a good answer, is designed to articulate a point. The First Amendment that we have today is completely divorced from anything in history, right? It's as if the First Amendment started with Holmes. I'm only slightly exaggerating. The way the court has interpreted the First Amendment basically picks Abrams more or less as a starting point. Like 1919, right? We say it was bad in the 1800s, in 1800, forget the next century. Holmes, there it is, right? Similar for the Free Exercise Clause, right? The Free Exercise Clause is pretty modern. It came around during the 20th century. Our Establishment Clause jurisprudence came around in the 1950s and 60s, right? It's a very modern body of law, similar to how we study substantive due process, right? It's a very modern body of law. The notion that, judges can define the sweet mysteries of the universe, as Justice Kennedy would say. So it's all modern, and I think a lot of it stems back to Justice Holmes. And again, you can like Holmes, maybe he's wrong, right? Maybe you can have a free society that doesn't have this much freedom. Maybe allowing all these socialists actually did injure our war effort. I don't know. But Holmes says this is a theory of the Constitution. Okay. All right, so any questions on Holmes and Abrams? Very important dissent. There's a great book. It's called The Great Dissent by a guy named Healy, H-E-A-L-Y, The Great Dissent. And it actually tries to explain how Holmes made it from Schenck, Debs to Abrams, like how that 8-month window happened. And it looks at a lot of Holmes's private writings and correspondences and things written about him. And the Cliff Notes version is he was influenced by some journalists who got to him. Working the refs, as they say, right? You don't see that anymore. No one does that anymore. What was it?
Let's go Patriots.
Let's go Patriots. Oh boy, yeah. Okay. All right. Okay. They have the end zone militia. I do like that part of their team. They have, when they score a touchdown, they do these little musket things in the end zone. Okay. Is there any questions on Abrams? Yeah, Cameron.
I was going to emphasize, but I realize this was legislation, but with the Virginia or with Holmes of the law, like the Virginia Kentucky Revolution, where you have guys like a Jefferson and Madison who are big time, very persuasive, talking about how they have this law that's not okay and things could step.
You mean if President Wilson had prosecuted a state legislature that wrote one of these things?
Yeah.
That's a good question. Oh boy, I mean at the time, I don't know if any states passed resolutions similar to Virginia, Kentucky. I can look that up. I don't know the answer. I can't imagine that the U.S. government would prosecute a state legislature. I just don't know how that would work. But it's a good thought. Good idea. Anything else on Abrams? Okay. So we have Abrams.
Free marketplace.
The marketplace of ideas. Marketplace of ideas. So we have Abrams, right? Now, so far, we're talking all federal cases. U.S. v. Debs, U.S. v. Schenck, U.S. v. Abrams. The next two cases, Gitlow and Stromberg, involve state prosecutions. These are cases that, how do I put it, hide the ball, right? It's sort of weird. We have Barron against Baltimore, which says the Bill of Rights does not apply to the states. And then we did Cruikshank, I mentioned that earlier, which said that the Bill of Rights still does not apply to the states after the 14th Amendment. And then, all of a sudden, we have Gitlow. And it basically adopts what came to be known as a theory of substantive due process. It says that the word liberty in the 14th Amendment embraces the First Amendment, the freedom of speech. So therefore, the states can't deprive someone of the freedom of speech. It's not well explained at all, and it's a huge change, right? The Due Process Clause says that you can't be deprived of liberty without due process of law. If you're given due process of law, they can take away your liberty. And isn't the basis of that a procedural right, right? If they give you a trial, they can deprive you of your liberty. What the court seems to say here is that what the Due Process Clause actually does is it imposes the First Amendment, says that the states cannot abridge the freedom of speech or press. It's not just that the state can't deprive you of liberty with a due process of law, it's that the states cannot abridge the freedom of press. It's the incorporation doctrine as we know it now, that the entirety of the First Amendment, the Free Speech Clause, is incorporated. Now, do they say that the entire Bill of Rights applies to the states? No. They did it one jot at a time, jot by jot, as they say. It took decades, and to this day, provisions still don't apply to the states. There's a case at the Supreme Court this term, it got argued 2 months ago, called Timbs, T-I-M-B-S. Does the excessive fines clause of the Eighth Amendment apply to the states? Right? The facts were, I think a guy in Indiana was dealing drugs out of his Range Rover. And basically the penalty for dealing drugs was fairly small, but they seized his Range Rover, which was worth a lot more money. And it's what's called civil asset forfeiture. And does that regime, taking all this money for a Range Rover for a small amount of drugs, violate the excessive fines clause in the Eighth Amendment? Indiana Supreme Court said, Eighth Amendment doesn't apply to us. Indiana can do it. So to this day, 2019, there are provisions of the Bill of Rights that don't apply to the states. But here they apply it very casually, right? And Gitlow, again, is a state criminal anarchy statute. He was a member of a left-wing socialist party. He published a manifesto, printed these copies. The court upheld the conviction under Debs and Schenck, but they said the First Amendment limits state action. The court says the liberty protected by the 14th Amendment includes the liberty of speech and of the press. But again, I want you to think about it. It's a weird fit because under the 14th Amendment, the state can deprive you of liberty with due process of law. They give you a trial. Have you been given due process? Yeah, okay, they can take your liberty away. It's a strange fit, but that's how the court started what became known as substantive due process. Okay. Yeah, Nathan.
Just to be clear, they didn't incorporate the entire First Amendment.
Nope, just a free speech clause. Yeah, McKinney?
So they're saying that the free speech clause of the First Amendment does apply to the states, right? But this guy was still, his conviction was outside.
Yes, yeah. I mean, that's the important point. Even though the First Amendment limited the state action, his utterances were inimical to the public welfare. His speech had a tendency to lead to anarchy and overthrowing the government, therefore could be punished. Gitlow is not good law either.
So they didn't really do anything for this guy. They just...
You know, it helped him one, but it paved the way for the next case, Stromberg, right? Gitlow is not nearly as important as Stromberg is. Also, they talk about deference, right? Towards the end of the opinion, they say that the determination of the state must be given great weight, and every presumption is to be indulged in favor of the validity of the statute. This is what you might call a presumption of constitutionality, right? Where we presume the statute's constitutional, and we try and stretch and save and do whatever we can to preserve the statute. Does anyone remember what case that might remind you of a presumption of constitutionality? What case? Come on. You were all with me at different times. Close. Said it. Caroline Prox, very good. That's it. It's been too long, right? What was that? Filled milk, yeah. How long did it take? 45 minutes, right? So we have Caroline products, which is an important case. So here in Gitlow, the court applies what we might call a presumption of constitutionality. That the court should presume that statutes are constitutional. What does that mean? The burden is on you, the individual, to prove that the statute's unreasonable. This was the opposite of Lochner, right? And Lochner, who had the burden was on the state. The state had to demonstrate that their law was reasonable. But by the time you get to the New Deal, and actually Gitlow's a little bit before this, 19 was a 25. But by the time you get to the 1920s and 30s, the court starts moving away from Lochner. And they reverse the presumption of liberty, as you might call it, with the presumption of constitutionality. And now the burden's on the individual. You presume laws are valid. But there's a problem with the presumption of constitutionality that was addressed in Caroline Products. What about when a law violates something in the Bill of Rights? Do we still presume the law is constitutional when a law on its face runs afoul of a provision of the first 10 amendments? Right? That is the importance of Caroline Products. Right? Caroline Products says we do not apply a presumption of constitutionality if a law limits something in the Bill of Rights. That's footnote 4. Footnote 4 does not rely on Gitlow. It relies on the next case, Stromberg. Because Stromberg got rid of this deference. Right? Stromberg got rid of the deference that the majority afforded. And I think we see this in Justice Holmes's dissent with Brandeis in Gitlow. Right? He doesn't presume constitutionality in his dissent. He actually asks, has there been a present danger proven by the government, right? Has the government shown there's a clear and present danger? No. He writes, every idea is an incitement, right? But this is not incitement. It stops short of that. So the harm is too remote. There's merely publication and nothing more. So you're already seeing Holmes with Brandeis shifting the case law again, right? You don't presume it's constitutional. It's a criminal prosecution. The burden is on the state to put forward evidence to show the law is valid, to show the prosecution can go forward. Here, that does not work. Okay, questions on Gitlow? Moving along very nicely. Any questions on Gitlow? All right, so the last case. Who am I up to? Costa, my friend. You want to give me the facts, please, in Stromberg?
Yeah, so it's basically, there's a California law that well, it starts out there, but it's a California law that says you can't display a red flag or banner.
Why? What's the red flag? Why is that? Who cares? Is Westlaw illegal, right? West flag? Yeah.
Communist Party.
Yeah. The red flag was a symbol for anarchism and communism, right? That was like their symbol, right? So Costa, stupid question. Is a flag speech? The court doesn't really address this point, but is a flag speech? Is it words? Red flag? A symbol, symbolic speech protected? Court doesn't really address this. We'll do this, I think, next class after the break, but when it's conduct speech. Is waving a flag speech? But anyway, we'll come back to it later. So Marissa, does the court uphold the prosecution here?
No, they reverse.
Okay, why?
Because they're protected against, wait, I'm sorry. Because it wasn't considered speech in his time.
Well, was the flag protected by the First Amendment?
Oh, yes, it was.
Okay, good. How should the court read the statute? Christine, how should the court read the statute? Are they deferential to the statute here? Louder? No. Okay, that's correct. No, why not?
They said that the statute was invalid because referring it to the 14th Amendment of the federal Constitution.
Do they think, is the text of the statute clear about what exactly is prohibited? No. Okay, good. Give me more. Okay, good. Very good. So here, instead of bending over backwards to try and find ways to pull the statute, the court says, look, we got a statute that limits free speech. We're going to read it as it is and not give it the benefit of the doubt. The burden is on the government to make a good statute. It's not our job to fix it, right? It's not our job to save it. If you want to think of Chief Justice Roberts and Obamacare, it's in one class, right? To get to a saving construction, right? We're not going to do that here. And this sentence from Stromberg, right, is cited in Caroline Products for the proposition that when you have a law that restricts something in the Bill of Rights, you do not give it the presumption of constitutionality, you give it a presumption of liberty. If it's an unenumerated right, like liberty of contract, Lochner, that's in a different ballpark. But if it's in the Bill of Rights, the courts will still give it strict scrutiny, which is effectively presumption of liberty. Okay, that's Stromberg. Questions on Stromberg? All right, so let me synthesize a bit. In my first, in common law, if you took me in the past, I always made a big fuss about saying you have to keep in mind what time you're in. And at different junctures in time, common law is very different. That is really true for this class. And the court goes through various waves and ebbs. So one of the challenges in this court is to keep track of how the doctrine progresses. Abrams, probably not good law anymore. I think the Holmes dissent, I think, is still good. Schenck and Debs, certainly not good law anymore. Gitlow, probably not good law anymore. Stromberg is still heavily cited. It's cited to this day. And we get to the symbolic speech about burning flags and burning draft cards. Stromberg plays an important role. Okay. Is there any questions on Stromberg or anything else? All right, yeah, Nathan.
So one of the reasons why those previous cases wouldn't be good is maybe it's because of like Stromberg and that they would be too vague, maybe?
Well, Stromberg, I think, probably would be valid law. But the other questions that apply, what you might call a presumption of constitutionality to a law about free speech, would not fly. Right? The courts apply either strict or what's called intermediate scrutiny to free speech regulations. Generally, there are exceptions to everything, which I'll have to deal with tomorrow morning. Anything else? All right, thank you all. Glad you're here, and I'll see you not next week, it's a holiday, but the week after.